On the morning of the 19th of November, 1965, near the town of Hasselton in Buchanan County, Iowa, school officials and law enforcement officers arrived at a one-room Amish schoolhouse with a bus. Their instructions were to load the children aboard and take them to the consolidated public school. The officials went inside. Outside, a group of Amish parents stood watching. One of the fathers shouted a single word, "Run!" The children went out and scattered into the cornfield behind the school, small figures in black clothing disappearing between the rows. A photographer from the Des Moines Register named Thomas DeFeo was there, and what he did next was decided for him. An Amish father named Aidan Yutzi told him to point his camera at the cornfield instead of at the bus. DeFeo did not understand the request and did not want to miss the shot of children being loaded aboard, but he turned the lens toward the corn. That photograph ran across 7 columns on the front page of the Des Moines Register the following day. It was reprinted in newspapers around the world and carried in Life magazine. Parents were arrested that day and fined for non-compliance. Within days, the governor of Iowa halted all further attempts to enforce the law against the Amish. 7 years later, on the 15th of May, 1972, the Supreme Court of the United States handed down a decision that still governs the education of every Amish child in America. Before we continue, don't forget to tell us which city you're listening from, and subscribe to the channel to support our community. Thank you, and let's continue. The total amount in dispute in that case was $15. 3 questions run through what happened in between. Why a school bus in an Iowa cornfield became a constitutional crisis. How are people who refuse on religious grounds to go to law ended up in the highest court in the country, and exactly what the justices gave them, because it is narrower and stranger than most people assume. The trouble in Buchanan County did not begin in 1965. It began with a map redrawn in 1947. That year, the Hazleton Consolidated School District was created, part of a statewide effort across Iowa to standardize and improve public education by merging small rural districts into larger ones. Consolidation was, by most measures, a genuine reform. It replaced scattered one-room schools with modern buildings, certified teachers, laboratories, libraries, and high schools. It also required buses, because the new schools were farther away, and it extended compulsory attendance into the teenage years. Every element of that package collided with the community it was applied to. The Amish near Hazleton belonged to what is known as the Buchanan affiliation, a group that had broken away from the Kelowna settlement in Iowa in 1914 on the grounds that Kelowna had grown too worldly. They were, and remain, among the most conservative Amish in North America. They do not permit running water in their homes, or flush toilets, or bathtubs, or bicycles. Their objection to the consolidated high school was not that education is bad. It was specific, and it was about age. Amish schooling ends after the 8th grade at about 14 and is followed by apprenticeship. A boy learns farming, carpentry, or a trade alongside his father and the men of the community. A girl learns household management, gardening, and the running of a farm alongside her mother. That period, from 14 to 20, is when an Amish young person acquires the skills that will support a family for 50 years. A public high school takes those same years and fills them with competitive sport, individual ambition, mixed social life outside the community, and a curriculum oriented toward careers the Amish do not enter. So the Amish built their own school with their own teacher. Iowa responded that the teacher was not certified, and that the school therefore did not satisfy the law. That was the standoff, and by 1965 the state had decided to end it with a bus. The photograph changed the politics of the situation within about 48 hours. Governor Harold Hughes imposed a moratorium on any further attempts to force Amish children into state-approved schools. He wanted time to work out a compromise, and the fact that a governor felt compelled to act that quickly says everything about how the image had landed with the public. The compromise took shape in 1967, when the Iowa legislature voted to exempt Amish parents from the state's education requirements. Under the arrangement, the Amish could use their own teachers, and their children were not required to attend school past the 8th grade. In exchange, the students had to sit for and pass the Iowa test of basic skills. That is a remarkably practical settlement. The state gave up control of who taught and how long children stayed, and kept one thing, which was proof that the children could read, write, and do arithmetic at grade level. But Iowa is one state. The exemption protected Amish families in Iowa and nobody else, and similar conflicts were running in Pennsylvania, Ohio, Kansas, and Wisconsin. 2 other things came out of that photograph. The first was that some of the Hazelton families gave up on Iowa and left. Among them was Adin Yutzi, the father who had told the photographer where to aim. The second was that a Lutheran pastor in Michigan named William Lindholm saw the picture in the newspaper. Lindholm was not Amish and had no personal connection to the community. What he saw was a religious minority being coerced by the state, and he decided to do something about it. In 1967, he founded the National Committee for Amish Religious Freedom. The committee existed to solve a problem the Amish could not solve themselves. Their doctrine of non-resistance discourages them from suing, defending themselves in court, or organising politically. Lindholm's organisation could raise money, hire lawyers, and litigate on their behalf with outsiders doing the fighting. Everything that happened next required that arrangement to exist. In the fall of 1968, in New Glarus, Greene County, Wisconsin, the local school district administrator filed a complaint against 3 farmers. Wisconsin law required parents to keep their children in public or private school until the age of 16. 3 families had stopped sending theirs after the 8th grade. The fathers were Jonas Yoder and Wallace Miller, both Old Order Amish, and Adin Yutzi, by then a member of the conservative Amish Mennonite Church. The same Adin Yutzi from the Iowa cornfield who had moved his family to Wisconsin and walked directly into the same fight. The children were Frieda Yoder, aged 15, Barbara Miller, aged 15, and Vernon Yutzi, aged 14. All 3 had completed the 8th grade in public school. None were enrolled anywhere afterward. The 3 men were charged with violating the compulsory attendance law. What happened next inside those families is rarely told, and it is the part that matters most for understanding the Amish. They did not want to fight. The Amish have a deep and old aversion to going to law, because litigation means asserting yourself against a neighbour and calling on the coercive power of the state, and both of those violate the doctrine of non-resistance that has defined the church since 1693. Their ancestors accepted expulsion from Alsace rather than take up a legal or physical defence. It took several months of indecision before Yoder, Miller, and Yutzi agreed to let themselves be represented by counsel at all. When they did, the National Committee for Amish Religious Freedom brought in a Pennsylvania attorney named William B. Ball, a specialist in religious liberty cases, and paid the costs. The families themselves were not funding a legal campaign. Others were doing it around them with their permission. That reluctance is worth holding on to because the state's eventual argument depended on portraying the Amish as a group demanding special treatment. In fact, they had to be persuaded to show up. The trial in Greene County Court was, on the evidence, badly lopsided. William Ball did not argue the case as a narrow question of attendance records. He built it as a demonstration of what the Amish community actually is, and he brought in experts from as far away as Philadelphia to establish it. His central witness was John Hostetler, the leading scholarly authority on the Amish in the United States, and himself raised in an Amish family. Hostetler explained the structure of Amish education, the vocational training that follows the 8th grade, and what secondary school does to an Amish adolescent's ties to the community. He was joined by an expert on public school regulation from the University of Chicago. Hostetler's testimony alone ran longer than the state's entire case. The court convicted the 3 men anyway. The Wisconsin statute was clear, the facts were undisputed, and a trial judge is not usually in the business of declaring state law unconstitutional. Each man was fined $5. That figure tells you what everyone in the room understood. $15 total, from 3 farmers, for withdrawing 3 teenagers from school. Nobody was trying to punish these men. The state wanted a ruling, and the defense wanted a record, and the fine was the ticket that let both sides move upward. There is one exchange from the preparation of the case that captures how deliberately it was built. Adin Yutzi informed the committee that he was no longer Amish, having joined the conservative Amish Mennonite Church. The lawyer's reaction was not dismay. He said good, because that way any ruling could be extended to the Mennonites as well. That is why the final Supreme Court opinion identifies 2 of the respondents as Old Order Amish and 1 as conservative Amish Mennonite. The composition of the defense was engineered so the precedent would cover more than one group. The Wisconsin Supreme Court took the case in 1971 and reversed all 3 convictions, with a single justice dissenting. The state court's reasoning went to the heart of the matter. Wisconsin had asserted an interest in compulsory education, and the court held that the state had failed to prove that this interest outweighed the constitutional protection of religious free exercise. This is the analytical move that defines the entire case. Nobody disputed that Wisconsin had the power to require education, or that education is valuable. The question was whether the state could demonstrate that the last 1 or 2 years of high school were important enough to justify overriding a religious practice. The Wisconsin legislature was not pleased. Neither was the state's legal establishment, which saw an exemption that could unravel compulsory attendance generally. So Wisconsin appealed to the Supreme Court of the United States, and in 1971 the court granted certiorari. Consider the position this created. 3 Amish farmers who had needed months of persuasion just to accept a lawyer were now respondents in a case captioned State of Wisconsin against Jonas Yoder, Wallace Miller, and Aiden Yutzi, before the highest court in the country, with national press attention. They had not appealed anything. They had won in Wisconsin and would happily have stopped there. It was the state that pushed the case to Washington, which means the precedent that now protects Amish schooling across America exists, because Wisconsin refused to accept losing. The National Committee for Amish Religious Freedom stayed with the case, and William Ball prepared to argue it. Oral argument took place on the 8th of December 1971. John W. Calhoun argued for the state of Wisconsin. His case rested on the state's responsibility for the education of children and on the danger of the exemption being sought. If a religious belief could excuse a family from compulsory attendance, what stopped any group from making the same claim, and what happened to the children whose parents made a choice they might later regret? William Ball argued for the families, and his approach was to attack the state's factual premise rather than its authority. The Amish, he maintained, do not oppose education. Their children complete 8 years of formal schooling and then continue learning in a structured apprenticeship that produces skilled, employed, self-supporting adults. What the state proposed to add was 1 or 2 additional years of a specific institutional environment, and Wisconsin had not shown what those years would deliver, that the Amish system did not already deliver. He also brought in the record built at trial, 3 centuries of Amish community life, a group with no welfare recipients, no unemployment claims, essentially no crime, and a functioning internal economy. 2 justices did not take part. Lewis Powell and William Rehnquist had only just joined the court and had not heard the argument. The court took 5 months. On the 15th of May 1972, the Supreme Court affirmed the judgment of the Wisconsin Supreme Court. The citation is 406 United States 205. The vote was 7-0 on the outcome, with Justice William O. Douglas filing an opinion dissenting in part while joining the result as to Yoder. Chief Justice Warren Burger wrote for the court. The core holding was that Wisconsin's compulsory school attendance law, as applied to these families, violated the Free Exercise Clause of the First Amendment, made applicable to the states through the 14th, because requiring attendance past the 8th grade interfered with the right of Amish parents to direct the religious upbringing of their children. Burger's reasoning turned on 2 findings. First, that the values and the programs of secondary school stood in sharp conflict with the fundamental mode of life mandated by the Amish religion. This was not a case of inconvenience. The court accepted that high school attendance genuinely threatened the survival of the community's way of life. Second, that an additional 1 or 2 years of high school would not produce the benefits Wisconsin had cited to justify the law. The state's own asserted interests, preparing citizens to participate politically and to be self-sufficient economically, were already being met by these families through other means. 2 features of the opinion are constantly overlooked, and they define its reach. The court did not create a general right for parents to remove children from school. It weighed one specific religious community against one specific state requirement, and it leaned heavily on the Amish record of 300 years of orderly, productive, self-supporting community life. A newer group, or one without that evidence, would not fit the analysis, and the court repeatedly emphasized that Amish education does not stop after the 8th grade. It changes form. The justices were not excusing children from learning. They were accepting a different institution as adequate. One justice was not satisfied, and his objection has outlived most of the majority opinion's admirers, Justice William O. Douglas agreed with the outcome for one of the 3 families and dissented as to the rest, and his reason was that the wrong people had been consulted. The entire case had been litigated as a contest between parents and the state. The children's own views had barely entered it. Of the 3, only Frieda Yoder had testified at trial about her own beliefs. Douglas's position was that the child, not only the parent, holds religious liberty. If a 14-year-old wished to attend high school, become an engineer, or leave the community, a ruling grounded entirely in the parents' religious rights would foreclose that possibility without ever asking the person most affected. The majority answered that it was neither necessary nor appropriate for every Amish child to state a view in the prosecution of an adult, and that what mattered were the parents' rights and the record before the court. That exchange is why Wisconsin against Yoder remains argued about in law schools half a century later. It is celebrated as a landmark of religious freedom and criticised as a case in which 3 teenagers had their futures settled by adults on both sides. It is worth noting what actually became of them. The Amish children of that generation grew up inside a community that, as the population figures show, most of their peers chose to remain in as adults. But Douglas's structural point stands regardless of the outcome. The case established a parental right, and the individual child's claim was left unresolved. The practical consequences of that May morning are visible in every Amish settlement in North America. Today, about 90% of Amish children attend private Amish schools, most of them 1-room or 2-room buildings. A single teacher, frequently a young unmarried woman with an 8th grade education herself, teaches all 8 grades in the same room. Formal schooling ends after the 8th grade, and vocational training within the family and community takes over. That system was legal in scattered places before 1972 through state-by-state accommodations like Iowa's. After Yoder, it was constitutionally protected everywhere. The demographic effect was enormous, and it was not what anyone in the courtroom was arguing about. Researchers who track Amish population growth have identified the parochial school build-out of the 1970s as the turning point in retention. The share of Amish young people who were baptized and joined the church rose from something below 60% in the 1960s to 85% and 90% in the decades that followed. A case about whether 3 teenagers had to ride a bus turned out to be the case that let the Amish population double every 20 years. The legal legacy is more complicated. The demanding standard the court applied in Yoder, requiring the state to justify burdening religious practice with an interest of the highest order, was substantially narrowed by the Supreme Court in 1990. In a decision holding that neutral laws of general application do not ordinarily require religious exemptions, Yoder itself was not overruled, and it is now generally explained as resting on the combination of free exercise with the separate constitutional right of parents to direct their children's upbringing. Which brings us back to the cornfield. 3 fathers were fined $5 each, $15, in a county court in Wisconsin in 1968. The men did not want to contest it. The state insisted on appealing after it lost. A Lutheran pastor who had seen a newspaper photograph paid for the lawyers, and the ruling that came out of it now governs the schooling of more than 400,000 people who never asked for a court case at all.